Hello everyone, and welcome back to the channel. I want to continue going over our document drops. Today we're going to do the order denying defendant's motion to suppress evidence obtained from a Google search warrant. So what I'm going to do on this one is I'm going to go over the highlighted version, and then I'm going to go back and I'm going to read the document line by line. We're going to dive into a crucial update into the Stephan Michael Sterns case. This order was in response to Stern's motion to suppress evidence obtained from a Google search warrant issued back in February of 2024. This motion was a big one. The defense claimed the entire Google search was unconstitutional. They said it was overbroad, it lacked probable cause, and stemmed from an illegal phone search. Let's break down how the court responded. The judge tackled the issue of consent. The court found that Stearns had voluntarily handed over his phone during a consensual interview. He even unlocked it multiple times and never once revoked that consent. So the court ruled the phone wasn't unlawfully seized. The consent was real and it was valid. Next, the defense argued the Google warrant was too broad and vague, but the court's disagreeing with that. They said the affidavit gave detailed reasoning. It clearly linked the Google account to suspected criminal activity. The scope, including metadata, cloud backups, and location history, was reasonable and clearly defined. The court said this warrant met the Fourth Amendment standard for probable cause and particularity. So far the judge has upheld both the phone search and the warrant itself. Now, this part's key. The defense tried to argue that everything obtained from Google should be tossed out, claiming it was all derived from an illegal phone search. But the court said nope, there's no evidence of coercion, no unlawful seizure, and the digital warrant stands on its own. Therefore, there's no basis to suppress the evidence. In the court's own words, and I quote, defendant's motion to suppress is denied in full. The search of the defendant's Google account pursuant to the February 28, 2024 warrant was lawful and does not violate the Fourth Amendment. End quote. This means the state now gets to keep and use over 1,700 files recovered from the account, IP logs, and the metadata, and any further analysis that stems from that evidence. So basically, this is a major blow to the defense, and it significantly strengthens the prosecution's digital evidence case. So now let's go over the actual document itself and read that line by line for those that want to hear it. This matter came before the court upon defendant's motion to suppress evidence obtained from Google search warrant, filed on February 6, 2025, and corrected on April 29, 2025. The court having reviewed the motion, the state's response, the arguments presented at the hearing on April 23, 2025, the court file, and being otherwise fully advised of the premises, finds as follows. Analysis and ruling. Defendant contends that all evidence obtained through the Google warrant must be suppressed. To support his claim, defendant makes three main arguments. Google warrant relied entirely on illegally obtained evidence. Defendant first asserts that law enforcement exceeded the scope of Mr. Stern's initial consent, retained his phone without proper authorization, and conducted a coerced midnight download. Because law enforcement used the information extracted from the searches to support the application for the Google warrant, defendant alleges that the state cannot justify the warrant under any attenuation or independent source doctrine because the warrant was built entirely on tainted evidence and intentional misconduct. Defendant concludes that the evidence must therefore be suppressed as fruit of the poisonous tree. Defendant fails to establish that his searches were coerced or otherwise improper. The evidence makes clear the defendant willfully and voluntarily unlocked his cell phone and gave it to Detective Tagler on multiple occasions and unequivocally consented to them viewing map data and documenting his search history. Even after Detective Tagler asked if a warrant is needed, defendant nevertheless consented during interviews. Most importantly, defendant gave consent to law enforcement to download the cell phone and to go through the phone. A reasonable person under the circumstances would understand the scope of the consent to include access to all contents that were searched in this case, including call history and GPS data. During interviews with law enforcement, defendant was free to leave. Consequently, defendant freely and voluntarily consented to the searches, and that law enforcement did not exceed the scope of defendant's consent. The state is therefore correct in its response that law enforcement relied on information properly obtained during consensual searches of defendant's cell phone to support the affidavit for search warrant. Consequently, the warrant at issue was not tainted and was not constitutionally invalid as the fruit of illegal searches. Next, defendant asserts that the warrant application fails to establish probable cause. To establish probable cause, a supporting affidavit for issuance of a search warrant must satisfy two elements. First, that a particular person has committed a crime, the commission element, and second, the evidence relevant to the probable cause criminality is likely located at the place to be searched, the nexus element. A magistrate is not required to leave common sense at the courthouse door when evaluating whether a supporting affidavit satisfies the nexus element and supports a finding of probable cause. Here, the affidavit for search warrant for defendant's Google account provided a sufficient basis for the court to determine that evidence related to child acts would likely be found on defendant's Google account. Specifically, the affidavit points to the fact that defendant factory reset his cell phone the same day Madeline was last seen. Detective Heller also indicated that interviews of defendant were conducted and the defendant consented to a search of his phone. During the search, several files of child sexual abuse material involving Madeline were located. Further, the affidavit stated that defendant's images were stored and backed up on his Google account. Additionally, the affidavit further describes that evidence related to interference of child custody was contained within defendant's Google account. Detective Heller detailed that Madeline was reported missing by her mother on February 26, 2024. Defendant had stated that he dropped off Madeline at Peace United Methodist at 8:40 a.m., although classes did not start until nearly an hour later. However, a license plate reader captured defendant's vehicle tag traveling away from Hunters Creek Middle School at 8:10 a.m. Madeline never showed up to school. State is correct that at the time the warrant application was filed, it was probable that other information on defendant's cell phone prior to the factory reset was backed up to his Google account, such as GPS data, which was described in the affidavit for search warrant. Based on this ample evidence, which was relevant to the probable criminality likely located on his phone, the warrant application sufficiently established the nexus element. Consequently, the warrant application was backed in substantial evidence satisfying both prongs of Sanchez. Defendants claim that the warrant failed to establish probable cause is therefore without merit. Defendant further argues that the warrant was overbroad in its time frames for searches. The warrant permitted the search of data from January 1st, 2020 to present, yet, according to the defendant, provided no factual basis for the expansive 4-year period. However, courts often note that child picture collectors maintain their materials for significant periods of time. Here, there is evidence to support that defendant was an individual that fell into this category, given that the material was his stepdaughter and that it was located on his phone and backed up onto his Google account. Accordingly, the warrant is not tainted for having an overbroad temporal scope. The court also notes that the warrant affidavit was not overly reliant on generalized and boilerplate language about Google services. The state is correct that the implementation of standard language in the search warrant related to the operations of Google LLC is helpful and relevant in the affidavit. The boilerplate language was accompanied by ample case-specific information. In his final argument, defendant contends that the warrant lacks required particularity for digital searches. Defendant avers that the warrant's authorization to search any and all stored electronic communications or files associated with the Google account is impermissibly broad in violation of the Fourth Amendment. To support his claim, defendant cites to Riley versus California. However, Riley is an apposite. In Riley, the Supreme Court of the United States held that a warrantless search of a cell phone seized incident to an arrest must generally be suppressed. Riley does not address in a relevant and detailed manner how search warrants must be particularly detailed when authorizing searches of digital data. The state cites to United States versus Lamb. In Lamb, the defendant challenged the particularity of the warrant when it sought all stored files in original format in individual files. The Northern District of New York noted that although the language does not limit the investigators to seizing only files of child's pictures, the court noted that the actual content of a computer file usually cannot be determined until it is opened. The court held that the motion to exclude the pictures from trial was denied. Moreover, the court agrees with the state that even if the warrant was impermissible as overbroad, the good faith exception nevertheless applies. The good faith exception applies when a law enforcement officer acting with objective good faith obtains a search warrant and acts in accordance with the warrant and scope. Suppression of the evidence obtained is not appropriate even if the court later determines that there was no probable cause. United States versus Leon. Exclusion of the evidence is appropriate in cases in which the affidavit is so lacking in probable cause that reliance on it would be unreasonable. Brown versus Illinois. Here, law enforcement did not provide any false or misleading information in the affidavit for search warrant. As stated through this order, the affidavit was not lacking in reliance, so law enforcement relying on the warrant was not unreasonable. Accordingly, the court finds that the good faith exception applies and suppression of the evidence is inappropriate. Accordingly, it is hereby ordered and adjudged that 1. Defendant's motion to suppress evidence obtained from Google search warrant is denied. Let me know what you think about the ruling in the comments below, and as always, thank you for hanging with Hio.